I flew a 172, then I purchased a 182, and now I fly a Corvallis 400. The Corvallis 400 wouldn't fit in the T hangar that I had over by Air 7, so I put it up for sale. My hangar sold. I sold it to a friend, and I moved to a larger hangar. Now that same friend that I sold mine to can't sell it because the hangars are virtually worthless while we go through this contract negotiation. So here I've extolled to my friend, hey, it's a short-term lease, don't worry about it, it's month to month, nobody's ever been evicted, and now he's got a basically worthless hangar until this gets corrected. Some of the other items are Section 10, vehicle storage. It doesn't describe well enough how many square feet it takes to have a vehicle inside the hangar. Just want it worded a little more clearly, say up to 1,500 square feet, one vehicle. It's obvious it's only the vehicle can fit. Like in my hangar, I have a vehicle under the wing of my aircraft, and it fits, no problem in my hangar. But it's not worded that way. It doesn't state under 1,500 square feet, one vehicle. Another item is the security deposit, which we spoke of. Item 16, again, ambiguous. Item 18, which is one of the ones they say they don't want to change, that's just asking for a for sale sign. I'm just talking about an 8.5 by 11 for sale sign to stick on the hangar so I can get some people interested in it. At some point, I'm going to sell this hangar, and I'm going to move also to Idaho. So that's my end goal, to retire in Idaho. But in the meanwhile, I've got kids and grandkids here, and this hangar is nice for me to fly into, put my aircraft inside there, leave my car in there. But I might be gone for 3 months to Idaho. What happens when I get a notice that someone saw something wrong and I don't get the notice because I'm in Idaho? My hangar is going to be taken from me, and my aircraft, which is in the hundreds of thousands of dollars, is going to be put up for sale based on a month-to-month contract at $200 a month? That's ridiculous. Thank you.
Thank you very much. Mr. Brian Pierrick, you are up, and Gene Barlow, you are on deck.
Doug Schoen.
Is this your council?
Thank you.
Sorry, give us 1 second. Bear with us as we get these handouts out. Thank you.
Thank you. What was that for?
So my name is Brian Pierrick. I'm the city attorney for the city of Camarillo. And I want to address paragraph 26, which is entitled Compliance with Laws, Regulations, and Policies. The handout that I've given to you is excerpts from an agreement between the County of Ventura and the City of Camarillo pertaining to the Camarillo Airport development and surrounding uses. This was entered into in 1976. So I've got the cover page is page 1, the signature page is page 2. What I want to direct your attention to is page 3, which is Exhibit B to that 1976 agreement. It includes Camarillo Airport restrictions. They're limited. They're listed there, 1 through 6. One of them, for example, is number 4. An aircraft weight limitation of 115,000 pounds, twin wheel, shall be in effect. So I've read the paragraph 26 of the draft lease. It's entitled Compliance with Laws and Regulations. Mr. Turner has explained to me previously that he was advised by Mr. Temple that there wasn't any need for the lease, in the case of RKR, to reference the airport, the 1976 agreement, because of paragraph 26. The problem is paragraph 26 refers to statutes, ordinances, orders, laws, regulations, and rules, and minimum development standards. It says nothing about the 1976 agreement between the city and the county and the restrictions that were in Exhibit B that I called your attention to. So if you'll turn to page 4 of the handout, what we are requesting is that paragraph 26 be revised to add after the word regulations these words: the restrictions in the 1976 agreement between the City of Camarillo and the County of Ventura, except to the extent, if at all, that those restrictions are preempted by federal or state law. So that is the request. I'm available to answer questions.
Can I ask a question? Do you think that in 26 it covers the JPA agreement between the county and the city?
No, I don't think so. It doesn't say it does. It doesn't say anything about agreements. It only says statutes, ordinances, orders, laws, rules, and regulations. None of an agreement is not any of those things. So there's an ambiguity here. As a matter of fact, that ambiguity was recognized by the General Counsel for the VCTC, Steve Mattis, in a memo that he submitted to the VCTC, in which he said that was an ambiguity, and it could be clarified by specifically adding the language that I've just suggested to you.
And you don't want to add the JPA language in there?
Well, you call it a JPA. I'm just
Powers
calling
Agreement?
I'm just calling it the 1976 agreement.
Okay.
It doesn't say it's a joint powers agreement, it just says agreement. So that's the title I'm using, and that's why on page 4 I referenced the 1976 agreement.
Thank
And
you for
we
the
think
clarification.
So we think it's very important to include, can I respond?
Yeah, absolutely.
We think it's very important to include in paragraph 26 a reference to the 1976 agreement, since the language that's currently in paragraph 26 doesn't say anything about the agreement or the restrictions that are in it. I know that Mr. Turner has raised in prior meetings this issue about potential federal or state preemption, which is why the language that you see on page 4 of the handout included a provision that there would be compliance with the agreement except to the extent preempted by federal or state law. We think that would cure any issue with regard to preemption.
Thank you.
And if there's other questions,
Any additional questions? Bert?
Number one, I appreciate you bringing this, but I reside in a different city, and I'll be quite blunt. On our planning commission, there are members that have legal professions such as yourself, and I've heard it said they don't appreciate getting things at the last minute. If there was an opportunity to get this to the board earlier, I'd recommend if you ever do this in the future, you get it to us earlier.
Well, actually, I've had this conversation with Mr. Turner. I've submitted numerous correspondence to him, and he had responded to me that Mr. Temple had said that this language was not necessary because of paragraph 26. So I understand what you said, and I apologize for the late delivery.
Thank you.
Mr. Chairman, if I may, for a point of clarification, he's referring to two different items. He's not this lease. He's referring to another discussion about another lease that we're not talking about in this agenda item.
Thank you for that clarification.
Mr. Chairman?
Can I respond to what Mr. Turner just said? The language that is here in this lease that's before you, I believe it is substantially similar to the language that's in the RKR lease with respect to compliance with laws and regulations and orders. So my point is the same. This paragraph 26 does not specifically reference the 1976 agreement between the city and the county. The city of Camarillo thinks it should, both in this lease as well as in the RKR lease, but that can be a conversation another time.
Mr. Chairman?
Let me finish my question, please. The second point is, if the lease were approved this evening without this, do you see your city taking legal action?
I can't say. I don't make those decisions.
Would you advise your city to take legal action?
I would need to review it.
Thank you. Thank you.
Sorry, I didn't realize you weren't complete. If appropriate, I would like to hear Kip respond to this particular matter. Now, I've heard the one side. I'd like to hear his side, if that's possible. I don't see him jumping up there, so I'm looking.
It may be more appropriate for me to ask Tom to respond to the legalities of why we would not be ready to do this. I don't want to put you on the spot, but
Well, and also clarify, this is a lease agreement for Camarillo Airport and Oxnard Airport, correct?
Can I
Thank you.
can I share one quick question, Mr. Chair? Is it appropriate for us to be negotiating between the speaker and the board at this time?
I think we should wait.
You know, I just want to be sure for protocol purposes. You know.
Public comment, he could address it after.
Oh, I see.
See the point? If we could address that after public comment is complete.
Yeah, after public comment, we can each ask our respective questions as well of staff and council. Thank you very much. Gene Barlow, you are up, and Mark Russell, you submitted a comment card, but there is no reference as to the topic. Is it this topic you want to speak to? Okay, thank you. So you're on deck then.
Good evening. My name is Gene Barlow, and I have a hangar at Camarillo. Thank you for the opportunity to speak this evening. I'm very concerned about Clause 38 in the lease, the immediate termination. The problem with it is it says that you can lose your lease for violation of any rule that's airport related. And the issue is there is no threshold of severity specified. It doesn't seem reasonable that you should be able to have your lease terminated for the equivalent of an FAA flying parking ticket somewhere for whatever reason. If you were to lose your ticket for some period of time, you still own the hangar, you still have an aircraft, someone else could fly it for you, and after the 30 days is over, you're back to where you were. It just doesn't seem reasonable that that such a drastic measure could be allowed by the lease for a potentially minor infraction. There needs to be some kind of threshold of severity here. There's a lot of things in the lease that need work. It's not ready to go yet. Please, please, it needs additional work. We've worked on this thing a long time, and we're getting really close, okay? We truly appreciate the effort that Kip has put into this, and he has made some major concessions for us. We don't deny that, and we totally appreciate it. But there are sections in here that need work, and I'm not going to belabor them. Just, it's not ready. We got to do more to make this thing right. If it were to go, if this immediate thing was to go to mediation, for example, the mediator would say, "Did you get the ticket?" The answer would be yes. What does the lease say? The lease says that the airport can terminate my lease for that. End of discussion. The language in the lease has to stand on its own, and it's not ready. There's things in here. This particular issue negates everything that we've gained from switching from a month-to-month to a term lease. The security that comes with a term lease is meaningless with this in here. I'm not saying that they're going to abuse it, but it leaves room for abuse. And there's so many things here that need to be fixed, and we're so close. Please, let's get this thing right rather than rushing it through. A few more weeks could make a big difference if we were to work together on it. Thank you for your consideration. I really appreciate it.
Thank you, Mr. Barlow. Mr. Mark Russell, you are up. I don't have any other comment cards after this, so if anyone else likes to speak on this topic, please submit a comment card now.
Good evening, everybody. Yeah, my name is Mark Russell. I know some of you folks on the board. You guys, those that know me will say the same thing my wife does. I practically live at Camarillo Airport. My wife complains about that, and I'm going to ride on his coattails. The threshold for a violation needs to be addressed properly, because without a threshold, we don't know where we stand. If we cut the corner coming into Camarillo and go right through a little bit of Oxnard's airspace before we contact somebody, I know somebody that's already been violated for that one. And it was meaningless. It didn't hurt anybody, but it was just right on the edge. Is that going to be a problem? Is that going to void my ability to get a lease? I'm a GA pilot. I'm a professional pilot for an airline. Some of you read a while back a crew that was flying into Sydney. They were trying to do the safest thing possible. I do this myself. They were going in there. They were assigned a short runway when there's a long runway available. The short runway was wet. There was a crosswind. They elected not to take it. They wanted the long runway. ATC said, well, there's going to be a 30-minute delay. They didn't have the gas to wait around 30 minutes, so they declared a fuel emergency. They were going to get violated for that. Would that count against me getting a lease if I happen to have that same situation? Because I did have one similar to that going into Melbourne, Australia. There has to be some type of threshold that we need to meet properly if this is going to be an issue. Basically, that's all I have to say on that.
Thank you very much. At this time, is there anyone else that would like to speak to the authority on this topic? Seeing none, we're going to close public discussion or public comment, and we're going to move to discussion and/or additional questions of staff.
Thank you very much, Mr. Chair. Just to disclose that yesterday I did meet with Scott Bearer, and he had expressed a lot of concern about the things that he articulated here this evening. And I just want to say, like, without addressing all the points, that a process like this is probably at its very core, at the very root of democracy. So on the one hand, it can't get any more democratic than what we are seeing here. So that's a very positive thing. On the other hand, in my capacity as a member of the City Council of Oxnard, I'm more used to the issue of policy making rather than attempting in any way to wordsmith or micromanage or weigh in on the details of a very lengthy contract, which now we've gone on a couple hours talking about a contract. And we could go on several more hours on this contract. In fact, we could go on maybe for a couple weeks over this contract. So I have some concerns I'd like to express to my colleagues. There's 10 people here, and one of the things that is so difficult to do is that there are 10 people, and maybe every one of us has different ideas about how we'd like to approach this situation. But to an extent, it's a little bit of a free-for-all, from my perspective, for 10 people to all weigh in on thousands and thousands of words in a contract. So I have concerns, Mr. Chair and members of the committee and to the staff, about, number one, the capacity of this organization, the Department of Airports. I don't know how many employees they have, but you're seeing a lot of them that are right here. And I have a concern that sometimes part of the problem is if there's disagreement, that you just don't go forward because the organization doesn't have the capacity to do it, because this becomes the top priority. This could be the top priority for the next couple of weeks. I appreciate the comments that, you know, with a simple meeting with the county council, we could get this resolved in 2 hours. But if it hasn't been resolved in 3 years or 4 years, whatever that time is, I don't see how 3 hours is going to be able to reverse 3 years of what seems to be somewhat not just contentious, but acrimonious, you know, and that's part of the concern I have, Mr. Chair, and members of this committee, and say to the staff that when we have major issues of contention here with the Airport Authority, it's always about the hangars. I mean, it just seems to never go away. The second thing I have a concern about, and I don't know because I haven't taken the time to do this myself about this contract, is one of the things I tend to rely on when there are all these sources of contention is this lease contract, because we had a member, Charlotte Craven, who had said, you know, it was standard procedure for, you know, leasing agreements, et cetera. But as far as benchmarking is concerned, I don't know if a contract like this, if we could actually say, you know what, this is an industry standard. And that'd be something that we don't get into the weeds over every single word in this contract, but rather, you know what, these provisions are not exceptions here at this authority or with the Department of Airports. It's kind of standard that this is what the contracts are. Now, it might be little deviations here and there, but I haven't done that comparison, and that's not my, I have to say, I personally don't have the capacity to do that. And the last thing is, what I said to Mr. Bearer is that in the past, in my time, so in the last 16 years I've served on this authority, 14 years out of the last 16. Voters gave me an involuntary vacation for 2 years. And one of the things I've seen is that when there's something really, really egregious that's going on, some of the things that were expressed here, people come right here to this authority, and in fact, we can never call ourselves an appeal board, but they come to this authority and they'll say, hey, this is what's going on. And I understand there was a lawsuit that was mentioned earlier here, and that we saw that all play out here at the Airport Authority. But you know, the people I've served with on this panel have been very reasonable, and if something's really that egregious, then the board, the person will come here before they go to court and everything. I know in some instances that hasn't worked. It's obvious because something ended up in court. But they come here, and I've seen a lot of things where the authority members give direction to and that's our job, to give direction to the staff. And we've given direction to the staff, and they've responded to it. Like, hey, can we go back? Can you work this out? Can we kind of give it a little bit more time? Because members or several members felt that whatever had taken place maybe was a little bit off bent. And that doesn't happen very often. I haven't seen that happen very often, but it has happened. So I don't know, Mr. Chair, members of this committee, and the staff, and to those members who came, those members of the audience that are here tonight, I just see it as a real quandary if we just give a blanket direction to the staff, not ready, not showtime, go back. And if they don't get it done in 3 hours, or they don't get it done in 3 weeks, or whatever, we're right back in the same position. So I don't know if my colleagues have maybe a suggestion on how we can work through this, but I don't see how 3 years can be resolved in 3 hours. I really don't. And some of these things just aren't going to get resolved. And I like how the county council was able to summarize it for me about, look, we have made changes, and that was acknowledged by the audience here, members of the audience. And then there are other issues for a variety of reasons that they could not address. So I just feel that, I mean, this is so deep, getting so deep into this thing. 10 members, 38 members of the audience here, 38 members, 10 members, the staff. Other than just saying, go back at it, let's consume the organization's capacity for an unlimited amount of time. I just have concerns about that. I want to say to the chair, and I don't know if I really have a recommendation because I'm a little bit perplexed on how best, I mean, do you say go back and work on it and it's indefinite? Do we say go back and work on it, but we're not going to negotiate any longer than 3 hours, and then we're right back here with 38, maybe there's 68 members next time. So I just want to say that I want to thank the staff for, it's been acknowledged that they've put a lot of hard work in here. I think we just want to get this done, and I appreciate the sensitivity to the way we talk about this, and I'd like to see it concluded. And I don't know if the committee, maybe there's a consensus by this board that, look, there are 3 or 4 things here we think you need to work on. Just give direction on those 4, and then let's move forward. And I just have to say, I think the 30-day notice, the violations of the FAA, I said to Mr. Barry yesterday, I don't know. I've never read the FAA regulations, but maybe you're smoking a cigarette within a certain distance of gasoline, but you're outside the gates of the airport, and that's an FAA violation, and then you could technically lose your lease. On the other hand, I could see somebody coming here saying, look, I didn't know I was smoking a cigarette. I didn't know that provision, and I think maybe members here would say, well, that is a little draconian, so let's do something about it. But I do have some concerns about violating the rules and the 30-day provision. That's what I'm concerned about the most. Thank you very much, Mr. Chair.
Yeah, Mr. Chair, first of all, I want to thank all the speakers, and I think it's important to know that we understand that the hangars are part of your property here in the Airport Authority. But I just want to thank Tom and Kip, and I know that Todd was here before he started this quite a while back. You've been here a year, but this has been going on for several years. And in fact, one of the things that I was reading in the report, and we all know that the forms that we've been using date back to 1985. And I think that we need to upgrade and to renew those leases. I'm not going to go through the discrimination end of it or about Andy and what happened to Andy and the dispute resolutions, because I think what I'm concerned more is that we protect the public. This airport belongs to the public. It belongs to the residents of Ventura County. And my concern is that. But I'm looking at recommendations 1 and 2 here that staff is recommending to approve the revised hangar lease agreement. And also to authorize the director of airports and designate to terminate the existing month-to-month lease and then go with a private lease. And the reason I'm saying that is because if you look on page 2, the key terms that Kip put together here and the authority is that the proposed lease says that the term limits runs for 15 years plus 5 years. They're looking at no reversion at the end of the contract. They can enter into a new lease. They can sell and transfer their hangars to other owners. They can remove or relocate the hangar. There's no transfer fee. There's subletting is allowed. Their motor vehicles are allowed in the hangars, and additional aircraft can go under construction. But there's a lot of things that I think are really benefiting the hangar owners. And I'm ready right now to approve the recommendations from staff. Item 1.
Mr. Chairman,
We have a couple questions on this.
can we have some Camarillo side?
That's my position.
Thanks.
Since we're on Oxnard
Just kidding,
side?
Doctor.
Okay.
Question.
Yeah.
No, go ahead if you want to.
I thought that I had put in before the doctor. That's all. I was kidding him. Anyway, this thing has been long running, but like I've told some of the people in this group, you get 5 pilots and you'll have 8 opinions, and I don't think that we'll ever reach the point of having 5 pilots and 5 opinions on this. So I have to remind Gene and Dave that I was involved in this when they first brought up the idea of redoing the hangar leases, and I reminded them that lease is like opening up a engine. Once you open the engine up in aviation, you have to fix all of the ADs that were ever on that engine, and sometimes they're not going to be what you wanted. I've seen the efforts of the original requirements, which was extending it away from a month-to-month lease and subleasing capability. And I think that the airport right now has got a lease that is probably 3 times better than what anybody thought they were going to be able to get out of a lease change. I do have one question. Can you tell me from the airport department, did the risk case go directly to court before he ever came to the authority? I don't remember having Mr. Risk come to the advisory commission or the authority before it became a legal issue of which case they couldn't talk about it. Could I get refreshed on that? Anybody? I know it was before Kip's time.
Before my arrival, so.
My recollection was that by the time we heard about it, it was already a court case and the department couldn't talk about it. I think that's true, but I'm not sure.
That's correct. What happened in the Andy Risk case is that he was issued a notice of termination for his month-to-month lease, and he filed a lawsuit, actually 2 lawsuits against the county. So he went to court straight away. It was not until sometime after that that the county pursued an unlawful detainer action.
Yeah. So I would remind you of the same thing that Mayor Flynn said, is that we have 2 bodies, the advisory commission and the authority, that I've seen take a very active role in the rights and liberties and responsibleness of the hangar owners as well as the Department of Airport. I don't think that we have tilted too far one way or the other. We've been pretty even. And I think that had we had a chance to partake in the discussion points with Mr. Risk, we might have resolved his issue before it got to the point of no return in the court battle. So, and I think that you need to take a look at the lease as it stands. May not be perfect. I think it'll give the airport a chance to show that it has good intentions and trying to win back the faith and confidence of the pilots. But it is an incredibly much better lease than where it was started.
Doctor?
Yeah, I was going to say that contrary to the mayor and the supervisor to my right, my experience has been a little bit different. I think Kip Turner is a breath of fresh air. I think there's been a great change since he's come, and I have a tremendous amount of confidence in Kip and his leadership. But there are a few little things that I think it wouldn't hurt, and I don't think that 2 or 3 hours, as they mentioned, will solve some problems. But I do think that there are a few issues that I personally would like to see straightened out. And I think with Kip's willingness to work with COHA and that we probably could do this. I understand that everybody's frustrated and they want to get this thing over with and call it a night. But I think that, you know, we can hold our feet to the fire. I'm talking about the staff and says, listen, we want you guys to come up with a resolution within the next 4 to 6 weeks and tell COHA they got to do something here. And there are a few areas that disturb me. And the people we have working now are not necessarily the people we're going to have 2 or 3 years from now. And I don't want to sign off on something that we could have resolved by being just a little bit more diligent. So that's sort of where I'm coming from. I feel the pressure and the rush to put this behind us, but I want to caution this to, if it requires another period of time to deliberate, I think we ought to do that.
Sure. I just have comments on three parts of it. I am not clear on the terms or the conditions for the immediate termination. The words are the same for number 28 and number 36, violations of all these things, but it doesn't say what degree of violations. And so, or as somebody put it, the threshold of severity. I guess I don't understand when one would click in and when the other one would click in, an immediate termination or a 30-day notice. As far as dispute resolution, and there was a lot of talk about that. Excuse me a sec. I think that the regular accepted way of dispute resolution between landlords and tenants is fine here. And I probably shouldn't, but I've got to say something about subleasing. I think that the extent to which the county has gone is very good to create goodwill. My husband and I have owned rental property since 1976. We would never allow subleasing. It is forbidden in all of our lease agreements. I don't think that's a good thing, but I don't want a double negative here. I'll support it anyway in spite of subleasing.
I had just a quick question. A gentleman spoke in regards to vehicle storage, stating that the aircraft suggestion was up to 1,500 square feet versus each. Is that something that you would advise to modify? Tom, I'll ask you. It just said for each, it's up to, so in case you have a 3,000, I don't know.
The way the lease is currently worded, you have to have 1,500 square feet of hangar space to put a vehicle in it.
Okay, so you can't do it any underneath.
That's the way it's worded. Yes.
Okay. Go ahead. Were you thinking about that?
I'm just that's a little weird, because I would guess that most of the 1,000 square foot Ts and above have a vehicle in them, and just to limit those until to 1,500 square feet is a little strange.
That's why I'm bringing it up.
The requirement is you should be able to get your airplane in and out of the hangar without an issue. I think that the people who have vehicles in a 1,000-foot T can get their airplane in and out, otherwise they wouldn't have it.
Right. Or a golf cart.
And I personally have a Miata that slides in, that the airplane slides over the top of.
That's why I'm asking. So that's one item I would want looked at. Second one?
The intent of that is to allow a vehicle up to every 1,500 square feet.
So can we modify it to say up to?
That one can be modified, I think.
Thank you, that was a good suggestion.
Could we